I wanted to say that we're delighted to welcome our two distinguished guests who both occupied the job of legal advisor at the State Department. Before I introduce them, let me say something about the office that they previously occupied. The Legal Advisor's Office at the State Department is the U.S.'s chief international lawyer. It is an office that is known for producing and being responsible for articulating the main positions of the U.S. government with respect to questions of international law. And even though the legal advisor, as head of the office, is the most visible person in that office, there are something like, is it 500 or so?
200.
I wish it were that many.
Okay.
About 200.
200. There are 200 lawyers who work in this office, who stay the same regardless of administration, very largely. Like many offices in the U.S. government, the change is most evident at the very top when administrations change. Today we're going to focus on a series of questions that the Legal Advisor's Office deals with, and both because of the fact that we thought it would be more interesting and it's also timely, we're going to focus on issues that actually are of some contention as the Legal Advisor's Office shifts from one occupant to another. But I should say before we get into it that the vast majority of issues that the Legal Advisor's Office deals with, perhaps 95% of all the issues that the Legal Advisor's Office deals with, are issues where there is surprising continuity given the polarization that currently exists in Washington. So what you're about to see today is actually an unusual cut through the set of responsibilities that the Legal Advisor's Office has. Let me say one other thing, because we're going to be talking today about the U.S.'s adherence to international human rights treaties. Now, one thing is, of course, the U.S. doesn't sign or ratify every international human rights treaty on offer, but the ones that it does sign, it is committed to proceeding through the process for monitoring compliance with these treaties. Each of the treaties, each of the UN-sponsored international human rights treaties has a human rights treaty monitoring body, and the U.S. government is obligated to present periodic reports to that body, to be interrogated by that body, and then that body produces something called concluding observations, which are basically every country's grade in how they did in complying with the treaty. Now, one reason for having this event right now is that we're in between two of the major human rights reporting bodies at the moment. The U.S. just went through its reporting on something called the International Covenant on Civil and Political Rights, better known as the ICCPR. You're now on notice that that's what that means when we all refer to it, the International Covenant on Civil and Political Rights. And the monitoring body there is something called the Human Rights Committee. The U.S. just went through its periodic review in the spring, and the concluding observations of that body were just made available in March. And we're going to be spending a lot of our time today looking at the concluding observations of the Human Rights Committee. The U.S. is also right in the middle of going through its periodic review under the Convention Against Torture, or the CAT, which is not an animal but a convention, the Convention Against Torture. And the U.S. has already submitted its periodic report, and it's about to go through its actual review before the Committee Against Torture in just a few weeks. So these are the two topics, these are the two issues that are very much on the table right now. We're lucky that both of our honored guests today have taken the U.S. through at least one review of each body, and so they both have some experience in this area. I should say that our topic for today is also extremely timely. Some of you may have seen yesterday's New York Times article by Charlie Savage that appeared under the title, "U.S. Seems Unlikely to Accept That Rights Treaties Apply to Its Actions Abroad." This may seem like an obscure problem, but it really goes to the heart of how it is that the U.S. understands its treaty obligations. And because this is now a timely question, there's a current debate within the Obama administration about how far human rights treaty obligations apply to U.S. actions abroad. We're going to take up that topic today. So having given you a little bit of a substantive introduction to what we're talking about today, let me give you an introduction to the people with whom we'll be having this conversation. And I'm very pleased to say that we're welcoming back to campus Princeton alum John Bellinger, who's now a partner in the firm Arnold & Porter. I said to him actually before we met today that usually Arnold & Porter was known as a firm that tended to lean rather to the left side of the political spectrum more than the right side of the political spectrum. But as he reminded me, the firm's international law practice has been headed by moderate Republicans for some time. John Bellinger came to work for Arnold and Porter after serving in a number of different positions in the Bush administration. He was counsel for national security. He was the counsel to the National Security Council of the U.S. government in the first Bush administration, and then switched over when Condoleezza Rice became Secretary of State to being legal advisor at the State Department. He had previously served as counsel for national security matters in the criminal division at the U.S. Department of Justice. He served as counsel to the Senate Select Committee on Intelligence, was general counsel to the Commission on the Roles and Capacities of the U.S. Intelligence Community, and was special assistant to the Director of Central Intelligence, William Webster, so had a very strong background in national security. In addition, right now, in addition to his role at Arnold and Porter, he is one of 4 U.S. members of the Permanent Court of Arbitration in The Hague, and a member of the U.S. National Group, which nominates judges to the International Court of Justice. And so, welcome back to Princeton. Our other conversation partner today is, and I actually should say, to my left is John Bellinger, to my right is Hongju Koh, just so to you it's left and right the other way around. And so I'm very pleased to welcome to campus Hongju Koh, who is currently Sterling Professor of International Law at the Yale Law School and a scholar in residence at NYU Law School, which I just learned. He's just returned to Yale Law School in January 2013 after serving for nearly 4 years as the 22nd legal advisor of the U.S. Department of State. I believe you were the 21st. You didn't count.
I counted them all.
Well, since you followed each other, I'm assuming you're the 21st.
We wish we were like presidents, where everyone sort of knows me at 21 and Harold is 22.
22,
but I'm not
yes.
sure it works that way.
Well, you succeeded John Bellinger directly. And Hongju Koh went to the State Department from having been dean at the Yale Law School, and he was on the faculty of the Yale Law School since 1985. Before that time, he did a stint in government service between 1996 and 2001, he was the U.S. Assistant Secretary of State for Democracy, Human Rights, and Labor. And he is, as many of you in the room know, someone who is a very frequent writer across topics in public international law and one of the major academic voices in international law debates. So we're very glad to have both of them here. Having now introduced our subject, let me actually start the conversation, if I might, by saying that, you know, when the legal advisor's office sees a reporting obligation coming up, how do you actually put together these reports that the Human Rights Committee or that the CAT Committee has to review? It would be helpful just to know something about the process so that people know that, for example, it's not your individual and personal opinion, although you have a strong role in this. John, do you want to start?
Why don't I start, since we went sequentially? And let me first say, one, it's nice to be back. And I want to say, I was happy because Kim gave me my first paycheck after leaving government. And it doesn't sound like a big thing, but as one of you may know, government pays very badly to begin with. But then when you get kicked out on January 20th or whenever you leave, you literally do not have a paycheck. And as my wife reminded me about 5 years ago, and Kim came to the rescue and let me come be scholar in residence here in the LAPA program for about a week after I left being legal advisor. So it's nice to be back. And I'm usually up on Harold's territory up in Yale, so I think this is the first time I've dragged him down to, we didn't cover you with orange and black, but we came close. The U.S. government puts together these enormous, voluminous reports to these treaty monitoring body. The treaty body, and Harold can probably give you more detail on the treaty monitoring bodies, but for each of these treaties, there's a monitoring body that consists largely of academic and other experts. They sit in Geneva and they hear reports on compliance from the parties to the treaty. There's a formal presentation of a couple of days headed by a delegation from each country. Generally, the United States delegation is headed by the legal advisor, the Assistant Secretary for Democracy and Human Rights, and then often someone from the Department of Justice. Before you get there, actually most of the work is done in the United States presents thousands of pages of background to these bodies. And so it takes years to put together the presentations covering every single possible human rights aspect, from tasers to prisons to corporal punishment in schools to all sorts of things. When I became legal advisor, we'd gotten a bit behind in some of our reporting, and so the career lawyers in the office and I worked together to catch up. And we presented our second and third reports to the Human Rights Committee under the International Covenant on Civil and Political Rights, and then a report also to the Convention Against Torture, and then also on the Convention on the Elimination of Racial Discrimination, the CERD. So we did 3 reports in 4 years, an enormous undertaking which required input from all U.S. government agencies as well as the states, and then is sent in, and then we get questions to which one has to respond. So this is a big interagency effort. And I guess I would say 98% of it really goes on beneath the surface by career policy officials and lawyers all across the U.S. government. So that's how these are put together. Mm-hmm. And Harold, you want to add in your administration?
Maybe the best story I can tell was in 1999. I went to Geneva with Madeleine Albright, who was Secretary of State, and the first meeting we had was someone who started complaining about the application of the death penalty in Georgia, not Georgia abroad, but Georgia in the United States. And the short answer was, we're the State Department. We don't have a capacity to tell people in Georgia what to do except through a very complicated federalism process. Those of you know my academic work, it's about norm internalization and how international rules get worked into bureaucratic systems. And one of the ways that it does is through this process. The United States has ratified a number of these treaties, the ICCPR being the most important, but also the Committee Against Torture. As the head of the Human Rights Bureau, I presented our CAT report, the torture report, in 2000. I presented our Universal Periodic Review report as legal advisor to the Human Rights, to the UN Human Rights Council, and the ICCPR presentation to the Human Rights Committee of the ICCPR was done last spring. Next month is the CAT presentation. Now, in 1998, President Clinton issued an executive order which called for a process whereby these reports would be generated. And it gave the State Department and the White House a capacity to require interagency members to put reports together. And we would regularly have meetings in which the equivalent of the number of people who are in this room would be gathered from various parts of the US government to put together the written presentation. And so the US report takes literally 2 years, the written report, I'd say 2 years to assemble, with massive recall of data and statistics from every agency. The most recent report that we did under the ICCPR involved something like 35 federal agencies all reporting. And then there's the oral presentation. So it's like a briefing process. You submit a written report. Sometimes there are issues that you have not resolved, and those are bracketed. And then when you go make the written report, they decide exactly what the head of the U.S. delegation is going to say. In that process, which is a multi-day process, you appear before these experts in Geneva, and they are, in the age of the internet, backed up by NGOs from all around the world. So everything you're saying is being tweeted out to various people. They're adding comments. You are getting questions. Those are being BlackBerried back to your office. And usually you have till the next morning to appear and give the answers. And you benefit from the fact that Geneva is 6 hours ahead. So literally, when I went to do the torture report in 2000, we appeared with model answers to about 500 questions. We got, over the course of the first day of presentation, about 100 questions. About 50 of them were in our prepared materials, and the other 50 we texted or faxed back to whoever was working on it, and they worked until nighttime, and they faxed it back, and we went to sleep and got up and worked all night, made the presentation, and went in and gave all of the answers to all the different questions. So it has a remarkable impact in terms of actually getting input from the federal agencies about what the U.S. does to comply, and it gives a process whereby the information that's given to you is fed back into the interagency process. So it's a very powerful tool. And then we even, at the most recent one, had a lot of NGOs appearing with us at a briefing immediately after. So as soon as we did our official presentation, we went to a different room, and a number of NGOs from the United States were present, answering questions from, again, a group this size. So it shows the actual process of the human rights networks described by people like, Catherine Stickink or Martha Finnemore in process.
So one of the things that this shows is that I think the monitoring process is partly designed to get the state to talk to itself and to sort of collect its own materials on what it's doing to comply. Just to give you some sense of...
Just a classic example is the word torture and cruel, inhuman, or degrading treatment is not used in many U.S. databases. However, police brutality is. So we can gather police brutality statistics from states and localities across America and then do a data search and then provide the information in answer to the questions about how many adjudicated cases do you have of cruel and what they call CIDT, cruel, inhuman, or degrading treatment, or the like.
Right, right. So I'm just going to give you a sense, since not all of you may know the ICCPR, of just the list of things, for example, that the concluding comments in this last process complained about on domestic policy, because we're going to spend most of our time thinking about the applications of this to territories outside the U.S., because that's currently the hot topic. But let me just give you a rundown of some of the concerns. So they were worried about stand your ground laws and gun violence. They were worried about fatal shootings by U.S. police departments. They were worried about exclusion of undocumented immigrants under the Affordable Care Act. They were worried about racial disparities in criminal justice, about the criminalization of victims of prosecution, about the non-inclusion of farm workers and domestic laborers in labor law, about mandatory detention of immigrants for prolonged periods of time, mandatory deportation of foreigners without regard to the seriousness of the crimes that they commit as the basis for their deportation. As always, there's always concern about the death penalty. There's concern that law enforcement officers are not required to act in cases of domestic violence, concern about the use of corporal punishment in schools, concern about the non-consensual uses of psychiatric medication and electroshock treatment, concerned about criminalization of eating and sleeping on the streets for people who were homeless, concern about the use of prolonged solitary confinement, concern about the availability of life without parole sentences for juveniles convicted of serious crimes. They're worried about the persistence of state-level felony disenfranchisement laws and insufficient measures being taken to protect sacred areas of indigenous peoples. Just to give you a sense of how broad the reporting is, the U.S. included all of these things in its report, and those were worries expressed back from the Human Rights Commission about things, just the areas where they were concerned, not the areas where the U.S. was found to be in compliance, just to give you a sense of the range. And also, that's a backdrop for saying that what we agreed to before the panel was to focus on what are really, I think, the hot-button issues right now in U.S. policy. And in particular, the biggest issue, I think, has to do with not the applicability of the International Convention on Civil and Political Rights within the U.S., but it has to do with how far the ICCPR applies to U.S. actions outside of its borders. This is extraterritorial reach of the ICCPR, and this is what the Obama administration is currently debating with respect to an aspect of the CAT Convention, because this is going to affect the position of the U.S. government as it makes its argument there. And so both of my interlocutors here have taken positions on this question of the extraterritorial reach of these conventions. And I'm wondering, perhaps we could start, since Harold Koh was referenced in yesterday's New York Times article as having been one of the leading advocates of extending extraterritorial jurisdiction of these conventions, which, by the way, has not been the US government position, certainly since 1995 and arguably before. So if you could explain why you think the ICCPR and or the CAT, particularly Article 16 of the CAT, which I think is what's up for grabs right now, we can explain this, why you think the treaties require that at least there be some extraterritorial reach.
So to put it in the most basic terms, these are universal human rights obligations. And so unless there's a limitation in terms of language, you would think it's crazy if we have an obligation to prevent, say, genocide in the United States, but we could commit genocide on the high seas, or that anybody else could do the same. So my working assumption with regard to these treaties is that they were intended to have a broad reach. Each of the treaties has their own negotiating history and their own text, and the various provisions have, in some cases, territorial limitations and some not. It turns out that the United States government has, at the time when I came in as legal advisor, adopted a strict territoriality reading with regard to both treaties, saying that the obligations under the treaties apply only within US territory. Obviously, that excludes Guantanamo, and Guantanamo is a major area for discussion of this issue. So, as legal advisor, one of the first things I did was to see whether this was a plausible interpretation. Now, if you read the memos, which were given to the New York Times, I had not discussed this with the New York Times, but they're my memos, I'm not going to deny them, and I defend them. They are correct in my judgment. And to me, they demonstrate that the strict territorial position with regard to the ICCPR is legally unsustainable, and I believe that the strict territoriality position with regard to the CAT is legally unavailable to be argued by US policymakers. It's just flat wrong. Don't take my word for it. The first position is laid out in a 56-page single-spaced memo opinion that I signed out in December of 2011. And the second one on the CAT is a 90-page single-spaced opinion that was signed out on January 21st, 2013, an hour before I left office. First of all, the U.S. torture, the Convention Against Torture has a number of different obligations. Some of them are explicitly universal. For example, the obligation to criminalize torture has no geographic limit. Others have territorial restrictions. And it turned out that in 2005, in a set of secret opinions that were put out by the Justice Department, they argued that the limitation on cruel, inhuman, or degrading treatment in Article 16 was territorially limited. Very much to his credit, John Bellinger, relying on the work of a previous legal advisor, Abe Sofair, who had worked for the Reagan and Bush administrations, challenged that. And the note that they wrote is, that John wrote, and the opinion of Sofair is also reported in my 90-page memo. The story that's in yesterday's paper, and I only know what I read in the paper, is that this issue is currently under debate within the administration as to whether to now change the position away from strict territoriality for purposes of the presentation to be given in Geneva next month. That's on November 10th. Today is October 20th. There are 20 days in which this issue will be presumably resolved. And so I don't know if what the paper reports is true, but what's certainly clear is that on November 10th or 11th in Geneva, a US representative, presumably the acting legal advisor, and the Assistant Secretary for Democracy, Human Rights, and Labor, who's now Tom Malinowski, will appear, and one of the first things they will have to address is this question. My view is they would be wise and legally correct to say that they abandon the strict territoriality position with regard to the CAT, but we'll see what happens on November 10th.
Would you like to comment since you've been referenced?
Sure. So I guess what I'll say sort of generally is I'm not sure that Harold and I are sort of that far apart on where we would come out as sort of as a policy matter. So I will sort of comment on sort of objectively sort of where I think the U.S. government is. I mean, I guess I should say, personally, I also served in the Clinton administration. I ended up being the legal advisor in the Bush administration, but I'm not inherently a political person, don't really have sort of political views on this. So my comments are more sort of objectively, what do I think, what has the U.S. government done historically? What do I think the U.S. government is going to do? So, so we've mentioned these two treaties, one, the International Covenant on Civil and Political Rights, and the other, the Convention Against Torture. So the issue that Kim is generally referring to and Harold's referring to is, do these treaties where we agree with other countries to do certain things, are we guaranteeing the guarantees in those treaties only to people inside our country or to everybody around the world? And you have to look at them individually because, frankly, one is harder than the other. The more difficult one is the International Covenant on Civil and Political Rights. Did our negotiators, it was negotiated by Eleanor Roosevelt in the 1950s, and then did our Senate, when it gave its advice and consent to the treaty in the 1990s, think that it was only securing these rights of liberty and life and privacy to people inside the United States, or was it guaranteeing those rights to people all around the world? And for 50 years, the U.S. government position has been, through administrations of both parties, that the ICCPR only applies inside the United States. That's not a political position. The first time the United States government was specifically asked the question by the Human Rights Committee was in 1995 to clarify its position. Do you think that the U.S. government will guarantee rights outside the United States government? And was asked to a Democratic legal advisor, Conrad Harper. So the Clinton administration said for the first time, clearly and publicly, no, it doesn't apply outside the United States. Now, they were reflecting the negotiating history where Eleanor Roosevelt had actually made a change at the U.S. government's request to make clear that the treaty applied only in our territory and subject to our jurisdiction. Harold, and I will let him elaborate some more, has taken the view, and I think you would say this is a personal view in your memo, this was not the view of the U.S. government, that position ought to be changed and that there's a basis to change it. And I think a lot of the arguments in Harold's memo are right as to why it should be changed as a policy matter. As a legal matter, though, I guess I should make clear, when the U.S. government appeared before the Human Rights Committee in March, it did not change its position. So it did not accept Harold's view on this. The U.S. government stuck with the position that it stuck with for 50 years. Here's, I guess, the difficulty, and it gets into broader issues of treaty interpretation. The Senate has basically relied on the U.S. government's position that applies inside the United States for all this period of time. If the U.S. government were to suddenly, the executive branch here, were to suddenly change its position and say, we've decided that this treaty that the Senate gave its advice and consent to actually applies to guarantee rights all around the world, that would be a very significant change in the U.S. government's position, and I think the Senate would be quite surprised. Some of you, at least in the room, will remember that one of Harold's and my predecessors even further back, Abe Sofair, got himself into extremely serious trouble when he unilaterally reinterpreted the ABM treaty contrary to the views of the Senate. And in fact, the Senate got so mad at him that they then adopted, at the insistence of then Senator Biden, something called the Biden condition, which basically said, henceforth, the executive branch will not change its interpretation of a treaty that has been agreed to with the Senate. Now, I think Harold will say, and he probably will say in a minute, well, it wasn't entirely clear what the Senate agreed to at the time in 1950, because that issue just didn't really come up. But I guess I would say to you, just intuitively, without having looked at these treaties, would you imagine that, actually when it came up to the Senate, it was in the 1990s, would our Senate have thought that it was guaranteeing the rights of life, liberty, and privacy basically to people all around the world or to people inside the United States? So I think the United States, one, has not changed its position, and I think it would be difficult to change its position. I think the Senate would get very upset with the executive branch. Now, here's where I agree with Harold. Now, the Human Rights Committee basically would like us, and you're going to get into this in a minute, Kim, basically would like us to apply these rights almost without limitation, because they feel that sort of everyone around the world would be entitled to certain rights. For example, the right to privacy, they would be protected from NSA surveillance. Harold's view, I think, is that it actually we'd apply it much more in a much more limited way to only people who are actually under our jurisdiction or control, which, for example, people in Guantanamo or people who are in a prison that the United States is operating. Our allies, Australia, Canada, the UK, basically say that the ICCPR does not apply extraterritorially, except in the extremely limited circumstance where there's essentially a prison under their control. And so I think what Harold is doing is aligning us with that narrow set of allies, which is a policy matter I actually wouldn't disagree with. I would just say that I think that it would be very difficult for the executive branch to unilaterally change its position without getting ourselves into trouble with the Senate and, frankly, jeopardizing our ability to get future human rights treaties, such as the Disabilities Convention, through the Senate. So bottom line, I understand where Harold's coming from on this. I actually don't disagree with his bottom line. I don't think it's going to happen, and I do think it would jeopardize the executive branch relationship with the Senate if we were actually to push that too hard. So do you want to disagree with some of that, Harold?
So there are a lot of subtleties that have to be clarified here. What you heard from John is sort of the conventional wisdom. It just turns out that a lot of it's not true. So let's start from the beginning. This has not existed.
That's why I'm sitting in the middle.
This has not been the interpretation for 50 years, but what everybody can agree is as follows. Eleanor Roosevelt was one of the key drafters of the ICCPR. A key wording change was made, which she endorsed just before it closed. The United States ratified it, and this exact issue of territorial scope was not formally discussed. The United States ratified the treaty in 1978, and in 1995, so less than 20 years ago, the United States makes its first presentation, and our mutual friend and predecessor, a Democrat, Conrad Harper, appears, and he's asked, what's the territorial scope? This was a few years after the famous Haitian refugee case, which I was one of the attorneys, in which the U.S. had taken a position and prevailed at our Supreme Court that it did not apply extraterritorially, or at least the non-return provisions. Conrad Harper was asked the question. He comes back with a very short statement. The language of the treaty is clear. It's strictly territorial. That's essentially the assertion that's made, and then the example was given of the role of Eleanor Roosevelt. Now, this argument or claim has now been examined by many expert bodies, and not a single one of them has bought it. The United States stands alone. The International Court of Justice rejected this. The Human Rights Committee itself rejected this. The Inter-American Court rejected this. Our allies have almost entirely rejected it. The only one that has not is Israel. So this strict territoriality interpretation is becoming increasingly anomalous. Not only that, it was never clear that after it was asserted based on this very quick assertion in 1995 that anybody ever looked at it. So the origin of the memo, the first memo, the ICCPR memo, was actually go back and look. It turns out this was not the original understanding. It turns out that this was not presented to the Senate upon the original ratification. It turns out the first time it was ever asserted as a position by the U.S. government was in 1995. It turns out nobody ever went back. The claim is somehow that Eleanor Roosevelt put in this language so that the United States would be free to violate the ICCPR outside of U.S. territory. Frankly, doesn't sound to me like Eleanor Roosevelt, and that's not, in fact, what her intention was. It turns out what she was trying to do was to link, the best reading of what she did was to try to link up our obligations to where we had actual power. So where the United States could influence or could control things or had effective control, it was required that they ensure that these rights be given. The obvious implication being that if the United States has effective control over aliens who are being held outside the United States in a place like Guantanamo, it must ensure their rights and that the geographic location doesn't exclude them. By the way, I worked on this memo for months. I think it's devastating. I don't think there's an answer. And no one in the U.S. government, and not John Bellinger either, has ever responded to it point by point to show where there's an error. There isn't one. I think, and I think it's increasingly untenable to just keep repeating the old story. Those things are just not true. Now, on the torture memo, there was a position that was taken by the Justice Department in 2005, and it is an even stronger assertion that I believe the claim that has been made recently is that there's a categorical bar, a strict territorial limit on the provisions of the CAT Convention being applied, and also a strict limitation on whether it applies in armed conflict. And I say this is so legally incorrect, it's not legally available. I would argue to President Obama that if he makes such an assertion that he's violating the law. And that's the issue that's now being debated. Now, if somebody wants to challenge that, I want to see the 90-page memo that proves that where the error was made in the legal analysis. I don't think there is an error. I think it's one thing to adopt something because you've been asked a question and you have to give a quick answer in 1995. It's another to stick with it. And it's even another to stick with it when the US government has already moved through an executive order, through the Detainee Treatment Act, and through actions by Senator McCain and others in Congress to actually extend these things as a matter of domestic law. All of these things exist. Are we actually obeying these as a matter of policy? Does that mean that a future president can change it and go back to a claim that you can use torture and cruel and inhuman or degrading treatment by someone simply by moving them to a black site outside the United States? That's why law matters, because if there's a legal interpretation which is correct, and a key point of both of my memos is that you can move to these positions without substantially changing the policy that now exists under President Obama. All President Obama has to acknowledge is that he's legally required to do it. He didn't just do it to be a nice guy.
So one, I forgot to address the second convention, the Convention Against Torture, which is where Harold and I do agree. As he mentioned, his memo actually cites a memo that I sent to the Secretary of State as well, saying that I thought this one provision of the Convention Against Torture, which is whether the prohibition on cruel, inhuman, and degrading treatment applies outside the United States. I had also disagreed with the Justice Department and had told the Secretary of State so, and so Harold fortunately cited my memo in his as well. Back though on the ICCPR, I mean, presumably the U.S. government looked at your memos and still came out where they were before. I don't know why they did that. I wasn't part of that review, but presumably lawyers across this administration decided after a careful review that they wanted to stick with their position, which they did continue to say back in March that the ICCPR doesn't apply extraterritorially. And so here I want to repeat something again, is I'm not really making a policy argument here. I'm just making an argument of, one, what has the US government done? It has not changed its position. Harold is saying they were wrong not to have changed their position, but they didn't change their position. I will raise the concern, though, that if they change their position, that it really could jeopardize our ability to get future human rights treaties through the Senate. I mean, the current treaty that's pending before the Senate is the Convention on Disabilities, which extremely unfortunately, some very conservative Republican senators voted down a year ago because, in fact, largely because they were concerned about the interpretations of some of these treaty bodies, that they felt that the treaty bodies make interpretations that they don't agree with. My concern here is if, this just isn't going to happen. The United States has made its view known earlier this year, so it's not going to change its view in the next 5 years. But if the US government were to unilaterally make a major reinterpretation of a treaty, contrary to a position at least that a former legal advisor had laid out in 1995, whether it went back further than that or not, it would jeopardize the US government's ability to get future treaties through. So this is a fine distinction. You can say that the right thing to do, which is I think what Harold is saying, would be to change the US government's position. But practically speaking, and maybe this is why the Obama administration didn't change its position, is that they felt that it was better to stick with the old position rather than to stir up a hornet's nest with the Senate. You have a better idea, Harold, than I, because you served in this administration, is why the administration rejected your devastating memo. And if it's irrefutable, why did it refute it?
Well, I think it'll take some time, but I think they'll get to the right place because I don't think they have a better argument. The bottom line was, the claim was that the language was clear. If the language is clear, you don't have to look to the structure of the treaty, the object and purpose, the negotiating history, et cetera, and so they didn't. It turns out the language is not clear. There are multiple interpretations, and my memo lays out the multiple interpretations. Once you realize there are multiple interpretations, you have to look to these other sources. And then the interpretation that was adopted in 1995 suddenly completely falls apart. Now, I think what happened in March is that the administration didn't have time to fully process and decide what to do about it. And so they stuck with the position that existed since '95. I completely reject the notion that the Senate, after all, my position is that the Senate was told one thing when they ratified the treaty, and it was changed in '95. To go back to the original interpretation is actually the thing that will convince them that there's a little bit of integrity in this process. And so let's set aside also the fact that not much is getting sent to ratify treaties anyway. So the idea that somehow this is the thing that's going to tip them strikes me as just politically unrealistic. And I think the bottom line here is very, very simple. The United States is becoming extremely isolated with regard to its interpretation of these treaties on this point. It will only become more isolated. Every external body that examines it rejects a strict territoriality position. This puts the United States in tremendously difficult position in doing joint operations with allies who stick to the extraterritorial position. It means that the U.S. faces concerns when it appears before international bodies. And it's going to have to address this issue. It's not going to go away. It will change. So the United States has changed its position with regard to don't ask, don't tell. It changed its position with regard to same-sex marriage. It will change its position with regard to this, and I predict that now with great certainty. It may take a little while for it to do the right thing, but I think it will. A further point on the torture issue. This is President Obama's signature difference. His signature change was the executive order in which he forbid the use of torture anywhere where detainees are held under U.S. custody and control anywhere in the world. given that he has issued this as an executive order, given that it's also required by a statute of Congress, what is the conceivable basis for denying the legally correct interpretation of the treaty, which simply says the same thing? It's belt and suspenders. To reject it is to raise suspicions, as it already has done in blogs and other places, that people want to somehow preserve some flexibility on this issue, when in fact, that flexibility is not something that this administration, I think, wants to have as a matter of domestic law. So why does it want to have it as a matter of international law?
So let me play devil's advocate a little bit on the torture question, because when the U.S. ratified the Convention Against Torture, it had to domesticate the statute in U.S. law. And when it did so, in the torture statute, the U.S. took on the obligation as a matter of domestic law to punish anyone engaged in, any U.S. national engaged in torture abroad. But that statute did not extend that prohibition to cruel, inhuman, and degrading treatment, CIDT, which is Article 16 of the CAT, right? And so, as a matter of U.S. domestic law, that was U.S. domestic policy, which is one of the reasons why the torture memos that everyone knows from the early years of the Bush administration defined away torture, right? And part of the reason why it was able, or why it felt it was legally necessary to do that, was precisely because Article 16 had never been domesticated in U.S. law by the U.S. Congress, and it had been the U.S. position that Article 16 did not apply extraterritorially, which is exactly why we're in this mess, right? So the question is, and this is where, I've always wondered what the answer is to this. If the Senate ratified the treaty without making a territorial extension, and if the Senate then adopted a torture statute that made that distinction, in other words, that criminalized torture but not cruel, inhuman, and degrading treatment, then do we have a domestic problem along the lines that John suggests, which is that the Senate had never intended the treaty to apply extraterritorially, and that it would be very difficult as a result for the executive branch to do a unilateral interpretation of the treaty that did that? This is just the devil's advocate question.
Well, I think I reject the notion that somehow in adopting Article 16, which is the prohibition against cruel, inhuman, or degrading treatment, which has a territorial limitation in it, that we were not implementing the anti-cruelty ban under U.S. law. The obligation was assumed in part because of domestic laws which already implemented that ban.
In domestic law, right, but this is the extraterritorial extension, right? Because the Torture Act actually...
Well, this is where John and Abe Sofair made pretty clear, Abe Sofair at the time, that while we were comporting the substance of the ban to the cruel, unusual punishment provision of the Eighth Amendment, we were saying absolutely nothing about the geographic scope. It was in 2005, in the wake of disclosures about things like black sites, that it turned out that there were Justice Department memos being produced which argued that the limitation was territorial and that the Eighth Amendment was territorial. It was to that which John responded with his own memo saying this is wrong, and where he cited Sofair's position going back to the time. And Sofair was the guy who negotiated on behalf of the United States for the treaty to begin with. Now, John, I think my view is actually a little broader than yours. You were speaking about Guantanamo. Since your view was this provision applies on Guantanamo, you're already outside the territory of the United States, so you reject the strict territoriality view. My view is that these provisions apply anywhere where detainees are under the effective control of the U.S. government. It cannot be that the U.S. can not commit cruel acts as a matter of law against people on Guantanamo, but can commit cruel acts against them in Bagram, or can take them to a black site somewhere and commit cruel acts against them there. If they're under effective control, the U.S. obligations under the treaty attach to the U.S. officials wherever they are. That's my view.
Mm-hmm.
Well, I think we'd probably agree on that. My memo was about Guantanamo. The question was whether the Article 16 provision applied to Guantanamo. I mean, I think, just so the audience kind of understands, since we're all sort of on one side, well, what would be the opposite argument? Why is there even an article in the New York Times that says there's an internal debate? Because because it doesn't do us all any good just to be on one side and help out the audience. You know, I think one concern that probably the Defense Department would have would be, you know, should this human rights treaty be applying to us? You know, we're bound, we in the military are bound by the laws of war, and that these human rights treaties should not be the applicable law that applies in, you know, military facilities. And I think our, you know, I gave a talk a few years ago, which was essentially a defense of Harold, when Harold was in office, called, at the Columbia Law School, called "Why the Legal Advisor Does Not Always Get What He Wants." And, you know, we would like to think that, you know, 21 and 22 are the center of the universe, and that the Defense Department and the CIA and the Justice Department will all do everything that we want to do. But unfortunately, as both Harold and I found, they do not. And so I suspect, without being part of this debate, if there is one going on right now inside the Obama administration, that if the State Department is arguing, as, you know, a series of legal advisors have, that this human rights treaty should apply, the Defense Department may be saying, well, wait a minute, you know, we have a hard enough time complying with our obligations under the laws of armed conflict, which have essentially identical prohibitions under Common Article 3 of the Geneva Conventions, which prohibit torture and cruel and inhuman degrading treatment, that the military is saying, wait a minute, don't pile another treaty on top of us that is now going to be confusing to us. And they've watched what's happened with the Europeans who have had to comply with the European Convention on Human Rights, and saying that this has been very difficult for them. So, you know, what I'm saying here really is not to defend that position, but just, you know, why is there a debate at all? I suspect that's what the debate is, you know, because otherwise, you know, there wouldn't be any debate. I mean, presumably there must be, you know, or the Obama administration would have changed its view a long time ago. I guess we will find out fairly soon whether they, you know, how this debate, if there is one, comes out.
Well, let's make this.
So let me just clarify, this is very important. What I said was legally unavailable were two different things. I said it was legally unavailable to argue that the Torture Convention applies only territorially, and it's legally unavailable to argue that the Torture Convention has no application in armed conflict. I mean, it's just, it's very clear that the notion of what's called lex specialis, that humanitarian law can be the only body of law totally displacing human rights law, is a controversial proposition. Take the ICCPR, for example. Does the fact that someone has rights under the law of war mean that you can prevent them from worshiping the God that they believe in, which is covered by the ICCPR, or do you have to apply both? Now, obviously, the exact relationship between the ICCPR and the humanitarian law provisions has to be worked out. But it cannot be that the fact that you're holding someone under the laws of war mean that your only constraint with regard to their cruel treatment is imposed by the laws of war. It's also imposed by provisions of the Torture Convention. Now, John is exactly right that there's an elaborate interagency process that goes into play to assert a legal position of the U.S. government. But where I disagree with John was when he said, this was my personal opinion. You know, I was the legal advisor. I mean, I can give an opinion of the legal advisor to my clients, of whom I have many, and those are opinions of the legal advisor. Now, it may well be that the opinion of the legal advisor of the State Department is different from the opinion of the legal advisor of another department, and it has to be worked out. The president can ultimately choose. So there are many positions where one agency's legal counsel has expressed a view, and it will take some time before the rest of the administration goes along. So, for example, I think on issues like don't ask, don't tell, or same-sex marriage, different parts of the government change their views on this subject before the government as a whole changed their position in litigation. I think the same also goes, for example, during the first days of the Guantanamo, as to exactly what the scope of the U.S. obligations were, but it did change over time in part because of litigation.
Now, this, I think, raises, we can maybe move to a couple of topics that are much more specific. And I think this has been the generic problem that has underwritten a lot of the conflict between the U.S. and the treaty monitoring bodies. But one of the things that came up in the context of the concluding observations of the Human Rights Committee was a concern about drones. Now, Harold, you've just said that it can't be the case that only the law of war constrains what the U.S. does in detention operations. But as I understand it, that's something like what you've argued in the drone context. And so let me just say something about what the Human Rights Committee said as they were worried about the U.S. policy on drones. They were worried about a lack of transparency of the criteria for drone strikes, a lack of independent supervision and oversight of the implementations of regulations regarding drone strikes, breadth of the definition and geographical scope of an armed conflict, an unclear interpretation of what constitutes an imminent threat, and so on. Now, I know one of the things that you also famously did as legal advisor was to draft a relatively well-known memo on the legality of U.S. drone strikes. And I wonder if you take the observations of the Human Rights Committee that actually the application of U.S. force abroad in the context of attacking foreign nationals on foreign soil is something that is a matter for the Human Rights Committee to judge under the ICCPR and the U.S.'s compliance with it. In other words, does human rights law apply in this area, and would you extend the extraterritorial reach of the ICCPR in the context of drone strikes?
So I gave a speech in March of 2010 to the American Society of International Law. That led to a series of speeches. And the last one, and the most important one, was given by the President of the United States on May 23rd, 2013 at the National Defense University, where he talked about what would be the requirements, and everything that you've just said, which is what the Human Rights Committee said, he said the same thing. Now, he expressed this in terms of presidential policy guidance. A public statement, one-pager was released at the same time. The guidance itself is classified. The real question now ought to be, and I take it that Bob Cohane and a colleague of his had a workshop on this afternoon. How do you elevate what is one country's standard into a regime? And from a regime into a set of international norms. Now, without going into details, there's been a fair amount of discussion among leading countries about exactly what the standards are, which is the beginning of a regime creation process, principles, norms, and decision-making processes that operate in a certain issue area. But it's a significant ways from that to a multilateral treaty. But it's a beginning point. Now, I've said since I left the government, and I've said it on numerous occasions in a series of speeches and blog posts, I think the United States, the administration has not been sufficiently transparent. And I think it has not done enough to promote standard setting, especially on a multilateral basis. I think it has a set of principles that it can and could embed, and it ought to be taking these out there and doing this. It's done so, for example, in the cyber conflict area. It ought to do more in this area. And particularly, it should do it before drone use for military purposes is extended to a bunch of countries who don't have the same kinds of commitments to the rule of law. So those standards are there, and they're there to be multilateralized, first through a regime process and then through a treaty process. And the question is how to accelerate that process. Obviously, the fact that we're now in yet a new set of conflicts with ISIL hasn't helped the situation. And so we'll see what happens from here.
Can I take a stab
sure.
at the drone? Because I actually think this is a good idea. I realized that for the last hour, this has been a very, I mean, we are on the Woodrow Wilson School, so we expect our debates to be fairly arcane, but this was even more arcane, and we brought it down actually concretely. So here's the question for the audience, is having listened to all this, should the Human Rights Council, which is the treaty monitoring body reviewing U.S. compliance with the Human Rights Treaty, the International Covenant on Civil and Political Rights, be able to review the legality under this Human Rights Treaty of U.S. drone strikes? and they came out and said that they had a whole list of concerns about U.S. drone strikes. So let me be clear. I've actually listed all the same concerns. I've actually been more critical of the Obama administration on drones than Harold has been. And if you want to go see my views, go look at the Stimson Center task force, where I actually came out as a policy matter and basically listed all the same concerns that the Human Rights Committee said. But here's the legal issue. Should the human rights, is this a human right protected under a treaty under the International Covenant on Civil and Political Rights? Are people in Pakistan or Yemen or Somalia, again, I've expressed concern about these drone strikes, but are they protected by this treaty? The treaty, and Harold's own memo here says that even under the position that he's advocating, that a state is only obligated to respect rights for persons who are under the effective control of the United States. So does that mean that individuals subject to drone strikes around the world are subject to the effective control of the United States, such that the Human Rights Committee should be reviewing U.S. compliance? And I guess to get even further in this, Harold, you also say in your memo that you think that U.S. military operations in the conduct of the armed conflict with al-Qaeda are properly governed by relevant standards of international humanitarian law, not by international human rights law. So I'm assuming that what you're saying there is that even if you and I both have concerns about drone strikes, that the proper group to be reviewing it is not the Human Rights Committee overseeing compliance with the International Covenant on Civil and Political Rights. So, you know,
you're conflating a couple things there. What is the relationship between humanitarian law and human rights law, or the laws of war and human rights law? And the bodies that monitor these is a subject of very substantial debate. And there are two extreme views. One is that all rules apply to everybody on both, with regard to both treaties. The other view, at the opposite extreme, is that one displaces the other. In other words, that if you're in an armed conflict, human rights law doesn't apply. And the view which I ascribe to is that some of the provisions apply, those that can be applied reasonably under the circumstances, and that therefore there is a role for human rights law to play in these circumstances, but it has to be worked out on a case-by-case basis. Now, the important thing, it seems to me, with regard to the drone operations is that is it the job of the Human Rights Committee to be the only monitoring body? To my view, they don't necessarily have the expertise to do that. That's something that, for example, the Red Cross is much better able to understand and evaluate in light of laws of war. But it doesn't mean that their views are irrelevant. And that the very question of effective control is something that can be taken up by human rights bodies and has been by the European Court of Human Rights. So the very question you ask, is killing someone an act of effective control over them, is the exact issue that's been before the European Court of Human Rights. And there can be some important debate and discussion about this issue. Now, it's much more clearly elaborated in the context of detention. You know, if someone has nobody else to turn to because they're in somebody's custody, that person also, who is the jailer, assumes certain obligations with regard to them. That's what the effective control standard means. And what's emerging is essentially, I think, a customary international law standard of effective control. In other words, the test is not territory. The question is, who is your governor? And if they are your governor, they are obliged to obey certain norms that limit what governors can do to the governed. And that includes not just acting against them illegally in warfare, but also violating their human rights when it's possible for them to respect those rights.
Well, I think this is helpful, though, because it does, I mean, I think this, you know, when people leave the room, and I see Mary Ellen is going to come up with a question here in a moment, but is it probably everybody in the room has got concerns about U.S. drone strikes, and we've all expressed different aspects of concern. Harold and I both have. The question is it, as a legal matter under this treaty, should this treaty monitoring body of academic experts who are monitoring compliance with the Human Rights Treaty be reviewing the activities of the U.S. military? So, well, one, you can certainly imagine the view of the U.S. military on that subject. But be that as it may, these are the debates that we at the State Department have with the military. At least as I read your memo, Harold, you're saying that U.S. military operations and the conduct of the armed conflict with al-Qaeda are governed by international humanitarian law, not by human rights law.
So wait, where does it say that, John?
Footnote 8.
It doesn't say not by human rights law.
It does. That's a quote.
Do you want to consult the source? Do you want your memo?
As I read what you were saying here, is you were trying to say to the military, don't be worried about my view here, because we're prepared to work with those components, meaning other parts of the U.S. government, to square the legal interpretation set forth here.
Footnote 8 says, John, 2005 report, Annex 1, emphasis in original. I don't know what you're reading
I'm looking at the footnote 8 of your ICCPR memo. Anyway, this may be too difficult for the next question,
Well,
moderator.
but actually, what I was going to ask actually leads from that, which is that if the drone program was one of the signature operations that was ramped up by the Obama administration, then the NSA surveillance was something that got started, at least, in its extreme form under the Bush administration. And of course,
Let me just clarify. If this memo does anything with great care, it in no sense takes a firm position on the lex specialis issue, and would certainly never displace human rights law completely with humanitarian law. So that's not in there, John. And having read this memo hundreds of times, it's not there. Now,
just to help the audience a little bit, what's going on here is a debate about what law applies in the context of either detention operations or drone strikes. And the options are human rights law, which would be the background law if there were no armed conflict. And we were having a debate about how far human rights norms extend beyond the territorial sovereignty of a particular country to its operations abroad. But if there's an armed conflict, then what happens is international humanitarian law, which is human rights law without a lot of the bells and whistles, which is to say the absolute minimum standards, kicks in instead. And one of the questions is whether when international humanitarian law kicks in, does it totally displace human rights law, or is it a special set of guarantees to the special set of circumstances that happen in the law of war? And I think the controversy here is over whether the drone strike issue is regulated. The rights of those who are struck, shall we say, are covered by international humanitarian law, in which case, and international humanitarian law under the law of war, people get killed, legally speaking, legally under the law of war. The question is who can be targeted, what are the criteria for doing so, and what kind of care needs to be taken to ensure that people who are not combatants are actually protected. That would be international humanitarian law. Human rights law is the background norms that apply regardless of whether you're in an armed conflict.
So let me just clarify, because I think the point that John is referring to is an important one. At the end of my ICCPR memo, I argue that a discussion should begin to determine whether abandonment of the strict territoriality position as a matter of law would disrupt current military operations. And I give a bunch of reasons why I think it wouldn't. One of them is that largely the activities of the U.S. military are governed by humanitarian law rather than by human rights law, in the sense that if you kill someone lawfully in an armed conflict, it's not extrajudicial killing that's banned by human rights law because an armed conflict has been declared, et cetera. And in fact, because the United States military is quite fastidious in its compliance with humanitarian law, it also turns out to be quite fastidious in complying with the various norms expressed there, like Common Article 3, which are also human rights protections. So what I was urging there at the end was, for those who think that this legal move would actually create operational dysfunctions, we should go provision by provision and see whether it actually does. And my guess is that it wouldn't. In the torture opinion, it's even clearer because President Obama has already banned these things by executive order, and it's already banned by statute. So the question is it simply a matter of policy? It's certainly not compelled by a correct legal interpretation of the treaty, and it's certainly not compelled by past U.S. practice that was adopted. The only time it was in these opinions by the Justice Department in 2005, which were later withdrawn.
I guess I would say this is probably, again, I don't know why the Obama administration did not change its position on the ICCPR, but probably one of the reasons is that they did not want to be reporting, all of these operations to the Human Rights Committee. Drones is a special subject because it gets everybody riled up, but let's take an even more concrete example, which, the operation against bin Laden, which was clearly a military operation. The Human Rights Committee, though, would probably take the position that if the ICCPR applies extraterritorially and bin Laden got killed in that operation, that they ought to be able to apply human rights law and get the U.S. government to report to the Human Rights Committee as to whether we had complied with the International Covenant on Civil and Political Rights in that operation against bin Laden. Again, Howard, I take it from your memo that you would say that would not be appropriate because any operation like that should be governed by the laws of war. But I think the Human Rights Committee would take a different position. They would say, wait a minute, if the U.S. government is engaging in operations around the world that have an impact on people's human rights, then we get to review that in Geneva. Again, you can imagine where our military would come out on that question. Anyway.
This is the difference between a hypothetical concern and a real concern. The Human Rights Committee has already evaluated the U.S. presentation, and it didn't say anything about bin Laden. So if what you're saying is true, why didn't they evaluate it? These are not unreasonable people. They just differ about the extent of the displacement of human rights law by humanitarian law.
But I want to get to this one last thing, and we're going to open to the audience for some questions. So if those of you who have questions could go to one of the microphones while we're working on this last answer. That'll give you a chance to line up in time. Because one of the things that the Human Rights Committee did spend a lot of time on was this question of NSA surveillance. And the Human Rights Committee was clearly of the view that when the U.S. engages in this widespread surveillance abroad, that it has these extraterritorial obligations to protect the privacy rights of those who are under surveillance outside the territorial limits of the United States. And so they were urging that the U.S. put limitations on data collection to specific targets, procedures for authorizing who may be placed under surveillance, limits on duration of surveillance, procedures for use and storage of collected data, safeguards against abuse. In other words, all of the things that need to be protected within the United States. And they're urging that the U.S. apply these extraterritorially. So I'm wondering whether, what you think about the Human Rights Committee's view of extraterritoriality in this case. But second of all, when the NSA surveillance programs were being authorized within the U.S. government, was this ever an issue that the legal advisor's office at the State Department was ever engaged with?
Well, that's a great question. It actually gets back to my point about the Senate again. And again, you don't have to be an expert in all these things, but would anybody in the room think that when the Senate was approving the International Covenant on Civil and Political Rights, where Article 17 does talk about a right to privacy, I think it would be quite reasonable to expect that states parties would be guaranteeing a right of privacy to people at home. But would our Senate have understood the treaty to mean that we were then guaranteeing a right to privacy to everybody around the world, and that therefore, essentially,
that we would put under surveillance, right?
Well, but the position of the U.S. or of the Human Rights Committee is essentially, if we can listen to you, you therefore are under the effective control of the United States, or otherwise they wouldn't be criticizing us.
That's right.
I just have a hard time believing that our Senate expected that they were essentially shutting down electronic surveillance. I mean, we can have a big discussion about the appropriateness of NSA surveillance, absolutely. But the question is that a violation of our international obligations under Article 17 of the ICCPR? I had to have a hard time in believing that our Senate, either then or now, would believe that by becoming party to the ICCPR that they essentially wanted to shut down the NSA.
So on that, it's pretty clear that the Senate thought it was ratifying a treaty for not just this age, but for the future. The question is what constitutes an arbitrary invasion of privacy and what constitutes effective control. My point is simply this: all of these things don't have to be addressed by exclusion of jurisdiction. If the U.S. is doing reasonable things, it can appear and defend, which it does, at these things and explain why it doesn't think what it's doing is arbitrary, or doesn't believe that it has people under effective control because of the way in which it's gathering its data. So my view is there is a tendency to want to say everything is outside the scope of the jurisdiction of some international body, so you don't have to answer to them. But we already show up there with 2,000-page reports and defend on the merits, and I don't think this is any different.
So now we're going to go to questions from the audience, and I might say that Bob Cohane was the person who, whose idea it was to have this session in the first place, so you get the first question.
Thank you. I get the first question. First, I thank both speakers for talking about drones and for apparently agreeing with the argument that Alan Buchanan and I made in this building today, that there should be a drone accountability regime, which we think of as not a legalized regime, which is impossible given the U.S. Senate right now, but an informal but institutionalized regime, which would increase the transparency and accountability of drone action by the U.S. and, as Harold said earlier, would set a precedent for others who will necessarily have drones in the future and who may not be as inclined to regulate them as we are. But my question is different. It's a question about democratic theory, which has been notably absent in this discussion. The U.S. Senate still exists, Harold. Is there no thought of asking it whether it would approve of this reinterpretation of the ICCPR?
My view is that there was a reinterpretation of the ICCPR. It was done secretly. My view is that the question is that a reasonable interpretation, or was it adopted in 1995 without congressional protest, and therefore the Congress agrees with it? I don't think most of, well, let's be honest, I don't think most members of the U.S. Senate had ever even looked at it or even thought about it. So the question is, are we going back to what the interpretation was that they approved when the ICCPR was first presented to them? That's what I think is happening. Now, there is a process, and the process would be this. If the United States decides to abandon strict territoriality, and just imagine what strict territoriality means. It means that we've adopted universal obligations, but we only apply them within our own territory. So we can violate all of these things outside of U.S. territory, not just on Guantanamo, but anywhere in the world where the U.S. is exercising effective power.
Yes, but the question of democratic theory is the question that Biden raised about the ABM treaty, which I recall vividly as you do, and that is the ability of the administration to give an interpretation which was not certainly fully accepted by the Senate, and which, in this case, has been for 20 years. The other interpretation has been dominant, without consulting the Senate on its reinterpretation. Whether I probably agree with you on the merits of the law here, but the question is one of process of the
No, the question, Bob, is.
Yeah, they willy-nilly say, okay, well, we changed our mind, and the Senate, we don't have to consult the Senate anymore. They agreed once upon a time to this treaty, which we are now interpreting a different way.
Bob, the question is, what did the Senate understand that it was agreeing to? And my view is they did not understand that they were agreeing to a strict territoriality view. So the idea, the change that happened was in 1995, when a position was taken of strict territoriality, and they didn't go back to the Senate then. You could argue then that the administration amended the treaty in 1995 and did not take it back to the Senate for review. The Senate didn't say anything. So are we saying now that because nobody says anything about it in the Senate for 19 years, that the Senate has accepted the new view And so to go back to the old view, which was the one that I'm happy to ask the Senate. I'm happy to ask the Senate.
I should stay out of this one because I'm enjoying it so much, because I agree with Bob, which is really essentially my point is, I mean, I don't disagree actually with a lot of the points, substantive points that Harold makes in his memo, but the process problem is, now where I do disagree is I just cannot imagine, and I not only don't imagine, I just don't agree that the Senate, when they approved this treaty in originally thought that it was guaranteeing rights all around the world. If it thought it was, then one, the executive branch would have had to have explained to the Senate how we would comply all around the world, and in fact, all of the articles in the transmittal package about compliance with the treaty all had to do with how we would do it inside the United States. So if what the executive branch was telling the Senate in the 1990s was, oh, by the way, we're also guaranteeing these rights all around the world, you would have thought that at least half the hearing would have been about, well, exactly how, to whom and when and where and how would we be ensuring these rights all around the world. I think the answer is that no one thought about it at the time. They either just assumed that it was at home or they just didn't think about it. And this is where I just can't agree with Harold that the original interpretation of the Senate, sub silentio, that it was so obvious that they weren't even going to address it, was that we were guaranteeing these rights to people around the world.
There's a reason that the memo discussing this is 56 single-spaced pages long, because it goes through all of this history. Remember that the ICCPR was the treaty that the United States submitted, the Human Rights Treaty, that had the most reservations, understandings, and declarations of any human rights treaty ever submitted. And there was no reservation with regard to territorial scope. No reservation. And the issue was not discussed. The interpretation was the one that had been put forward at the time of the original submission. And the memo that I signed out in December 2011 goes through exactly what the U.S. presented to the Senate, exactly what the Senate voted on, exactly what was said between 1978 and 1995. And your conclusion from that should be, if you go through it carefully, which no one had done before, that this interpretation, the strict territorial interpretation, was never accepted by the U.S. Senate.
So if the Senate thought that it was actually at the time guaranteeing a right to privacy to everyone around the world, and that it was so obvious that they didn't even take a reservation, they wouldn't have even, in a hearing or a question or any senator, have actually said, now to be clear, executive branch, we want to make clear you are understanding that this is guaranteeing a right to privacy with anybody who we can touch around the world. I just can't believe that the Senate understood that. I think it kind of went over their head. They missed it.
Let's get another question here.
I mean, the simple point is this. If you want to take an interpretation which is different from one that's been put forward for 19 years to the Senate and let them talk about it, fine. And if somebody says something like what John said, it would be, well, that's a dramatically broad over-reading of what you think this provision is all about. So if you want to actually look at the treaty again, senators, and understand what the actual provisions mean, rather than relying on cartoon depictions of it, it's time for you to look at the treaty again in light of modern realities, which I think is fine.
Why don't we put these, with your permission, these two memos on the LAPA website connected to the announcement for this event, so you can read it for yourself. And if you have any contrary documents, we can post those too. And let me just get a couple more questions before we close.
That's the important point. I would love to see where this 146 pages of analysis makes mistakes. I'd love to see them.
Okay, well, we'll put it up so everyone can look.
I've yet to see a single detailed rebuttal of any part of these two documents, even though they've been out publicly since March.
Our next question. Why don't you introduce yourself, John?
Hi, Jonathan Hafetz. I'm a LAPA fellow. So thank you all for, three of you, for a great discussion. I had a question about the scope, and then I just had a question about the competence that you raised, John. So one of the rationales that's been put forward, or what's out there for U.S. intervention in Syria, for example, against ISIL has been that they're on, and elsewhere in the past, that the drone strikes, operations would be justified because Syria is unwilling or unable to address the threat that's emanating from its territory. So what are the implications of that theory for the notion of the extension of human rights protections under a theory of effective control, right? Because essentially you're saying a territory is essentially ungoverned. I don't mean you, but the theory is that it's ungoverned, and so that the U.S. or another party would be stepping in where in an uncontrolled state and exercising what would be effective control. So would the ICCPR or extend, for example, assuming it applied extraterritorially, under those circumstances, how would it affect it? And then the other question about the competence. So, John, you had said, that the sort of discomfort with the Human Rights Committee evaluating U.S. drone strikes by the military, and I'm just to probe you, kind of what's behind that. Is it because it's extraterritorial, or it's military, because it's purportedly armed conflict? I mean, and how would that be? I mean, it'd be different, but would it be really different in principle from the Human Rights Committee evaluating, say, the Mexican government using the military at home, where they're engaging in, the lethal use of force in something that they might describe as an internal armed conflict. So I don't know why one would be something that would be sort of beyond the competence of the Human Rights Committee and the other not.
You want to take the first one, Harold? Or should I take the second one? I can take the second one. I mean, I think the view of the military, I mean, Harold and I, when you're a legal advisor, you are the top international lawyer for the U.S. government. But it doesn't always mean that you get your way on every view. If it was, Harold's memo would be the law. So we've got to work these things out with the Justice Department, with the Defense Department, with the White House counsel's office. In this case, I think the Defense Department would say, we try scrupulously to comply with the laws of war and the principles of distinction and proportionality and all of the normal laws of war, but that we think that the Human Rights Treaty is intended to cover human rights issues inside the United States, and even if it applied outside the United States, it would not cover situations of armed conflict. So the use of a drone strike under the views of both the Bush and the Obama administrations has been that there's an armed conflict going on with al-Qaeda, and so therefore, if we need to explain it to anybody, it would be explaining it under the laws of war and not for compliance with the Human Rights Treaty. And again, I just want to repeat, almost every single one of the concerns that the committee raised are concerns that I have raised in the Stimson Center Task Force. Bob, you and I probably would come out in the same place on transparency and oversight. But it's what legal standard should the U.S. military be held to account to? Should it be held to account to a group of human rights compliance body who are monitoring compliance with the Human Rights Treaty, or should the military be complying in an armed conflict when it's conducting a military operation with the laws of war? And I think the military would say the latter.
A lot of militaries would say that, right?
Yeah.
Let's give Harold a chance to answer your first question.
So somewhere between explicit consent and unwilling or unable is implicit consent or toleration. And the question is whether we're in a very funny situation. Assad opposes ISIL, and I think he's happy to have actions taking place. Will Assad consent to American strikes on his territory? No, because that will mean there could be American strikes against him on his own territory. So the Syria situation is not like, say, Somalia, as it was, where there are large parts which are essentially ungoverned territories, or Yemen, which large parts are it's the equivalent of something happening on the high seas. It is the rubric of unable or unwilling which is being tested at this moment. Does that actually cover situations where they know about it, but they're not going to object to it? And you all know of other situations where that's the case.
Let me say one more thing, and then we'll go to these two. But one thing that did not come out today that everybody needs to understand, if it's a takeaway, and it's related to the question that you answer, is what is the actual jurisdictional competence of these treaty bodies? And the answer is, I think Harold and I agree on this, is that it is not binding on the United States. These are advisory. We treat them as with respect. We treat them as authoritative because they're the people who are set up to monitor, but they are not binding. When the countries enter into these treaties, we don't agree to be bound by the interpretations of these bodies. Conservatives get all riled up by the comments made by these treaty bodies because they are often pretty wacky. They criticized, what country was it, for having Mother's Day, saying that Mother's Day was, somehow discriminatory, and it set conservatives off. The answer is, my view is, don't worry about it. They're not binding. These bodies say some very useful things, but sometimes they just make statements that are out to lunch. One of the reasons we're having difficulty getting through the Disabilities Convention is that conservative senators have objected violently to statements made by these different treaty monitoring bodies. If I were up testifying and they have asked me to come testify, I would say, don't worry about it. We're a big country. We can stand the criticism. It's not binding. And we get more benefit out of the treaty bodies' criticism, frankly, of other countries. And when Harold and I have to go and stand up and take our lumps before the bodies, that's just part of the process. But the takeaway should be, what these treaty bodies say is not binding on the United States.
Well, I think the takeaway should be that the United States can withstand criticism and respond to criticism which is not well grounded in law. I mean, the example that John gives, which I think is a useful one, because the Convention for the Elimination of Discrimination Against Women is supposed to monitor that treaty. In Belarus, there's a holiday which depicts women in traditional roles, and it's a state-sponsored day in which women are encouraged not to work outside the home, and it's called Mother's Day. The committee said that this was inconsistent with the equality guarantees of the treaty, which Belarus had assumed. Now, this got translated to our Senate as they hate Mother's Day. And by the way, when I said that I thought that the United States should ratify the CEDAW, which hundreds of other countries have ratified, that got translated into, I am opposed to Mother's Day. And at my confirmation hearing, my poor mother is sitting there, my mother. And people are saying, well, Professor Koh, we know that you are opposed to Mother's Day. And my mother, who I had told, Mom, don't make a face or anything. She's just going, no, no, no. And she came out and said, I want to tell everybody, you always respect Mother's Day. You take me out to dinner. So, I mean, there's a telephone problem here, or maybe a little bit of willing ignorance being exhibited. But the fact of the matter is there are good and bad arguments made by these experts. The ICCPR, Human Rights Committee, had people like Lou Henkin, Jerry Newman at Harvard, our new member, Sarah Cleveland. These are persons of extraordinary ability. Nigel Rodley, who is an extraordinary human rights expert, is currently the president of the Human Rights Committee. So their views are entitled to be looked at with care and responded to with the care they're given.
So actually, we're running short of time, so what I'm going to do is take one more question, and I'm sorry for the two who came later to the microphone, but let's take your question last, and the other two are invited to come up and talk to our speakers afterwards. Yes, you should introduce yourself.
My name is Laura Galt, and I'm a joint degree student with Harvard Law School, and I previously worked for Public International Law and Policy Group. My question...
A great organization.
Yeah. Paul Williams says hi. The ICCPR, the American and European conventions, and also the Banjul Charter all put inhumane and degrading treatment together with torture in the same article, whereas the Torture Convention breaks them out. And part of the effect of that, I think, has been that many of the rulings will just say that there's been an article violation within the regional human rights courts rather than saying that torture has occurred. I was wondering what the U.S. policy on this is or has been, and I guess what effects you think the two different approaches have.
Oh
John,
boy,
you wanna
that
start?
one's too hard for me. I don't have an answer to that one, honestly. I hadn't focused on the fact that they are elided in the ICCPR as opposed to in the CAT, the two standards are broken out. I mean, what I will say, and this touched on what you said earlier, Kim, is the standard in the Convention Against Torture is so important that we do criminalize it all around the world by anybody. The prohibition on cruel, inhuman, and degrading treatment is only criminalized in areas subject to our jurisdiction. So we would not criminalize if some other country, individual in some other country subjected one of their own nationals to cruel, inhuman, or degrading treatment. That would not be something that we would criminalize because it's not as bad as torture. Torture is a universal norm. But as far as the difference in the ICCPR, I assume they are elided because the ICCPR is such a broad umbrella treaty that's only one provision. But Harold may be able to help you out here.
It's a good question, but there are three different points. First, cruel, inhuman, or degrading treatment is a term of art to describe things that have not risen to the level of torture. So take, for example, at Abu Ghraib, where people are riding on top of naked prisoners. They may not be torturing them, but it's certainly degrading and inhuman, and so it ought to be covered. Number two, a reservation was put on by the Senate, which argued that you could construe CIDT, cruel, inhuman, or degrading treatment, consistently with the U.S. Eighth Amendment jurisprudence. But the wording is different. A cruel and unusual punishment, which is administered to someone after they've been adjudicated a convicted criminal, is different from cruel, inhuman, or degrading treatment you might impose upon a detainee who's never been charged with a crime or convicted of a crime. So it is the term cruel, inhuman, or degrading treatment which has a broader international scope. Now, in fact, the U.S. courts have held that you can bring a case under the Alien Tort Statute for cruel, inhuman, or degrading treatment. And if you're trying to evaluate what it is, it turns out that looking around the jurisprudence of different countries is very helpful. For example, in 1990, the students in my clinic at Yale Law School brought a case against a former Haitian dictator who was accused of having ordered that people be put in something called the Jack position, which is that their arms are put up behind their back and a broomstick is put under their arms. Now, did that rise to the level of torture? We weren't sure. But when we looked at the jurisprudence of the European Court of Human Rights, it turned out that the exact same tactic when used in May's prison against Irish prisoners was called cruel, inhuman, or degrading treatment. So that gives you a sense that when you're not clear that something rises to the level of torture, it's still forbidden under the scope of these international treaties.
Actually, if I can just add one quick thing on that this was, I think, one of the little bits of mischief that gave rise to some of the interpretations of the U.S. torture statute by the memo that did not come out of the legal advisor's office, but out of the Office of Legal Counsel in the first Bush administration, when one of the things they did was to look around the world at cases that had interpreted either Article 3 of the European Convention, where they're twinned, or the ICCPR. And in both cases, what you see is that courts that were adjudicating these cases were very often using, how to put it, so as not to alienate the country completely to try to get compliance, would often call something cruel, inhuman, and degrading treatment that may have risen to the level of torture, but you could see them trying to humiliate the country less in some ways so as to be able to get some kind of compliance, because it didn't really matter. If the treaty doesn't distinguish, then you don't actually need to have a very fine-grained sense of where the line is, where cruel, inhuman, and degrading treatment flips over into torture. And then, of course, what happened in the U.S. torture memo, where the U.S. law at that time did draw a sharp line between torture, which was criminalized everywhere, and cruel, inhuman, and degrading treatment, which was not criminalized everywhere for U.S. forces, then you needed to draw the line. And because other international bodies had not had to, the U.S. torture memo took the shape that it did, because it didn't have a lot to go on in terms of figuring out exactly where to draw the line. So the Convention Against Torture separates them, but that was why when the U.S. only domesticated, in a sense, one piece of it, which is to say the part about torture, but did not put in the torture statute, cruel, inhuman, and degrading treatment, it gave rise to the need both to distinguish them and also some of the problems, I think.
And there's a tremendously important point on which I think John would agree, which is the Justice Department is not the expert on treaties. They may be the expert on the domestic aspects of treaties, but it's the State Department that negotiated the treaties. And that's one reason why the Legal Advisor's Office, with its 200 career lawyers, should be an authoritative voice on what a treaty means. So it's very significant if Abe Sofair, who is part of the original negotiation, looks at a memo written in 2005 by the Office of Legal Counsel and says, I don't agree with that interpretation of the treaty, which could be opportunistic or based on a few snippets of evidence which are given undue weight and doesn't take account of full interpretation. Now, as John points out, when the legal advisor is given an opinion, that might not be the opinion of the entire U.S. government either. But at least with regard to issues of international law, expertise is on the side of that opinion.
So I think we've reached the end of our time, but I just want to say that one of the things I hope you've all seen from today is that actually the U.S. government, in some sense, has a two-headed process for legal interpretation. There's the Justice Department and the Office of Legal Counsel, which gives advice to the executive branch, the Legal Advisor's Office at the State Department, which is the chief international lawyer for the U.S. government. And I think one of the interesting questions is how those two offices work together, which we couldn't deal with today. But maybe we'll bring you guys back to talk about how it is that the U.S. gets a single legal opinion out of its domestic interpretation of law going on in one office, its international law coming out of another office, and how under most administrations those offices work together.
But
how under
Kim,
some they didn't.
Kim, John and I are both smiling at the notion that it's a two-headed process. We have an interagency legal process on these issues where there is the National Security Council legal advisor, and sitting in the room are the legal advisor of the State Department, the head of the Office of Legal Counsel of the Justice Department, the National Security Division of the Justice Department, the General Counsel of the Department of Defense, the General Counsel of the CIA, the General Counsel of the Joint Chiefs of Staff, and then depending on the issue, the General Counsel of the Treasury, Homeland Security, and Commerce Department or whatever, and all of those individuals are trying to converge on a legal interpretation. So it's much more than two heads. What's really remarkable,
True.
What's really remarkable is that opinions are produced at all.
Good place to end. Thank you both.